So let's quickly revise Indian Contract Act. If there is any doubt, you can ask me and we can see that and we can go forward. Yeah. Okay. First we started with people. What do you mean by a contract? What was a contract, people? Contract was an agreement which was enforceable by law. We consider that as a contract. Now, an agreement to be enforceable by law, we need to satisfy certain essential elements. The essential elements were certain things were given under section 10, some things were not given under section 10. What was not given under section 10? There has to be two parties. There has to be intention to create legal relationship. We had one case law also here, that was social and domestic agreements can never be a valid contract. The case law you saw there was Balfour versus Balfour. Fulfillment of legal formalities, that means if at all there are any other conditions under any other law that has to be complied or satisfied, it is your duty to comply and satisfy that. For example, like insurance contracts has to be in writing, so it has to be in writing. But in general, oral contracts are also valid, no? But when insurance contracts are specifically to be in writing, it has to be in writing. Next one is certainty. The contracts has to be certain, not vague. 5 liters of oil is vague. 5 liters of groundnut oil is certain. Next one is possible to perform. It should not be an impossible act. So me asking a dead man to act is an impossible act. So such things are not valid. The next one we saw was as given under section 10, that is agreement, free consent and all these cases. So this is what we'll be seeing now throughout the units. Again, the way we did it when we started, like we'll do it in the same way. First we'll start with first thing. People, the state of Gujarat versus Ramanlal S and Co. We have not yet done. We'll be doing it in Indian Partnership Act, Unit 1. That time we will be doing this particular case law. Yes, sir. Okay. Now next we started with something called types of contract. The types of contract can be classified on the basis of validity. First one as valid contract. What do I mean by valid contract? A contract which satisfies all the essential elements. Next one is called void contract, 2J. What do you mean by void contract? A contract which ceases to be enforceable by law. So when you made this, it was valid. Later on, it becomes invalid. Such type of contract is called as void contract. Example for void contract is destruction of subject matter. Huh?
Changing. So death of a person.
Death of a person. I didn't get yours.
Sir, destruction or deterioration?
Deterioration. Okay, destruction or deterioration. Operation of law or alien enemy or things like that. All are the example. Next one is people. Voidable contract. What do I mean by voidable contract? Now you have seen what? Whenever the consent of the parties are not obtained in their free will. So when free consent is not taken, the contract becomes voidable. The definition, how do you write? When an agreement is enforceable by law at the option of one party and not at the option of other. So when one party decides whether it has to be enforced or not to be enforced, we call it as voidable contract, 2I. Okay. Next one is called as illegal contract. Agreement which is to do any acts which are forbidden by law. We call it as illegal contracts. The best example is whatever we saw. What is that? Opposed to public policy, unlawful object, unlawful consideration. All of that will become illegal contracts. Next one is unenforceable contracts. What do I mean by unenforceable contracts? A contract which is complete, but it has certain technical errors which cannot be enforced in court of law. They are called as unenforceable contracts. Like you have underpaid the stamp duty, or there is a mistake in spellings, or things like that. We call such things as unenforceable contracts. Okay, what is the difference between void contract and voidable contract? Void contract is valid when it was entered. Basically, first thing you can write definitions as we just saw. Next one is void contract is always valid when it is entered. It becomes invalid at the later point of time. Voidable, it depends upon the option of one party. If the party decides to treat it as valid, it will be valid. If not, invalid. In void contract, always the consent was taken free. There was no problem in consent. In voidable contract, the consent was not free. Someone forced you, undue influence, fraud or misrepresentation or something has happened. But void contract, the contract is always valid only, no? Yes or no? So those differences try to remember. A void contract cannot be performed. Here it is your option. The void contract does not grant any legal remedy. The party whose consent was not free has the right to resign the contract within a reasonable time. If resigned, it becomes a void contract. If it is not resigned, it becomes a valid contract. What is the difference between void agreement and illegal agreement? What is the difference between void agreement and illegal agreement? Void agreement is? Okay, definitions. Void agreement, void contract alla. Void agreement is nothing but it's not a contract at all. Agreement which has not satisfied the essential elements. We call such things as a void agreement. Example is agreement with a minor. We call it as void agreement. Illegal agreement is anything which is done for forbidden by law. Void agreement, there is no punishment. In illegal agreement, in IPC, that is in BNS, there will be punishment. Void agreement, remember, the collateral contracts may not be void, they may be valid also. Whereas in illegal contracts, the contracts which are collateral, that means connected to the illegal contracts, will be tainted with illegality, meaning any contract which is connected with illegal contract will also be considered as an illegal contract only. Remember that. Yes or no? Remember that is the important thing we have seen there. On the basis of formation, a contract can be classified into express contract, implied contract. Implied contract, the best example, express is by words or written, spoken or written. Implied is in the cases of circumstances or based upon the conduct. The contract comes into the picture. Implied contract also consists of tacit contracts. Tacit contracts means silent contracts. Next one, sir, is quasi contracts. Quasi contracts we'll see when it comes. E-contracts is nothing but people also called as EDA contract, cyber contract, mouse click contracts. When a contract is entered between two parties using a electronic means. In electronic commerce, different, that is, they also do it through electronic data interchange. What is the EDI people? It's nothing but whenever parties, one system communicates with another system. So whenever you place an order on Amazon, Amazon is programmed in such a way that you will immediately get a confirmation email. No one is by default. So no one is doing it manually. Such type of communications are called as EDI. Yes, Sam. So best example is email. All of those are your best examples of your electronic contracts. On the basis of performance, the contract can be classified into executed contract. Executed is where the obligations of both the parties are done and dusted in the past. Next one is executory contract, when the obligations of the party is still pending. When both the obligations are pending, we call it as bilateral executory contract. When only one party obligation is pending, we call it as unilateral executory contract. We have seen when we wrote there only, what is that? Bilateral executory contract can also be considered as reciprocal promises. Yes? Okay, done. Next one, people, we came to offer. Offer can be classified into, first one is called as general offer. General offer means an offer given to public at large. The example, the case law we had seen here was Carlyle versus Carbolic Smoke Ball Company. The next one was people specific, but one more thing in general offer. How is an acceptance given in general offer? Following the conditions, terms and conditions, that itself will be termed as an acceptance. You need not again specifically communicate the acceptance. So following the terms itself is considered as an acceptance in general offer. Carlyle versus Carbolic Smoke Ball Company. Next one is called as people specific offer. Specific offer is nothing but an offer given to a specific person. In such cases, the acceptance should also be given by the specific person only. Random person cannot give it. The case law we had seen was Boulton versus Jones. That shop case. I wrote a letter to one person, another person sent me the grocery. Boulton versus Jones. The third one is called as people cross offer. Cross offer is nothing but when two parties exchange a identical offer. That means A says, I want to sell my car to you for 5 lakh. Are you interested to buy? Without knowing this, B also writes a letter to A saying that I am interested to buy your car for 5 lakh rupees. Are you interested to sell? I also write a letter to you. You also write a letter to me. Without knowing each other's letter we wrote, that is only called as people cross offer. Exchange of an identical offer. Remember, cross offer never leads to a valid contract because there is no S there. Both are question marks. There is no full stop. Agreed? The next type of offer is called as people counter offer. Counter offer is nothing but people in our simple terms. I can also call it as a negotiation. When the party says something, you add your own terms and conditions and then you reply. Now this becomes an offer. This offer stands revoked. This comes to an end. Agreed? Yes, sir. So if you are seeing counter offer, you can read along with its two more topics. Revocation of offer, last topic. How does an offer gets revoked? Whenever there is a counter offer, the first offer always is revoked. Now this becomes an offer. Yes or no? For example, I want to sell you my land for 5 lakh. You say, I will agree to buy your land, provided I want to pay the money in 2 installments. Are you okay with it? Now I'm agreeing to buy, but with my own terms and conditions. Now 2 installments, you should say okay. Now who is giving acceptance? You are giving an acceptance. Then who made an offer? He made an offer now. Then your offer came to an end. That's why remember counter offer, the first offer always comes to an end. Hello? Yes or no? That is one topic. One more thing. With counter offer, what is the other topic you can relate? Acceptance should always be unqualified. You can never have a qualified acceptance. Qualified means what? You should not have any terms and conditions attached to your conditions. Mean to your contract. When you're accepting, you should accept it as it is. If you're adding your own terms and conditions, it becomes a qualified acceptance. That's why it comes in your rules of acceptance. And acceptance has to be always unqualified. So both the things will come under counteroffer only. Agreed? Yes, sir. Okay, next one, sir. Standing or a continuing or a open offer. What do I mean by standing or a open offer? What is standing offer? Whenever an offer is kept open for a certain period of time, we call it as a standing offer. Remember, sir, a standing offer, before it is revoked, the parties are free to, before it is accepted, the parties are free to revoke it. I might have told the offer will be open for 10 days. If you have not yet accepted, I may revoke it within 5 days. Even that is valid. If the contract is not accepted, I am free to revoke it. Is this clear? Yes. Okay, done. Next one, sir. Essentials of a valid offer. It must be capable of creating legal relationship. It must be certain. It must be communicated to the offeree. A has to tell it to B. If it is not communicated, it is not a valid offer. Example, here we saw case law, Lalman Shukla versus Gauri Dutt. For counter offer, what is the case law? Neil versus Merit. Remember, it must be made with a view to obtaining the assent of the other party, meaning you should have a free will. If will is not there, people, then the offer is always considered as not a valid offer. Fifth one, sir. It may be conditional. That means I can say you will get a free delivery only if you satisfy 300 rupees a minimum requirement. Offer should not contain term that non-compliance of which would amount to acceptance. You cannot say if you do not reply, I assume it is an acceptance. I cannot say if you keep quiet, I assume it is an acceptance. All that cannot be a valid offer. Same thing will come in acceptance also. No, mere silence cannot be considered as an acceptance. Offer is different from mere statement or intention. So a mere statement of an intention, a father telling I would want to make you my next CEO of the company, this cannot be a valid contract. It is just a mere intention. It is just an announcement. It's not a valid contract. An invitation to an offer is different and an offer is different. In a shop, whenever they say 50% off, they display some goods. That is just an invitation to an offer. They are inviting you to the shop. That whatever display they put, that itself is not an offer. They are inviting you to make an offer. You come inside. You take what you want. You come to the cashier. You ask. We will give acceptance. So offer is different. Invitation to an offer is different. Third one, a mere communication of information. What is the case law? Harvey versus Facey. Bumper hall pen. I asked two questions. Can you sell me your bumper hall pen? Second one is, what is the least possible price? They replied 900 pounds. This person said yes. Remember, I just replied my least possible price. I did not answer the question of whether I want to sell it or not. So mere quotation of a price, mere reply can never be considered as an offer or an acceptance. The last one is, a prospectus is never considered as a offer. It is just an advertisement. I will give a prospectus, that is, I'll give an advertisement in a newspaper. Tomorrow we are coming up for an IPO. Please apply. You will get an allotment. This is not an offer. This is just an invitation to an offer. Okay. Next one, that is what we saw. Harvey versus Facey. Okay, next one is acceptance. When the person, okay, legal rules of acceptance. Acceptance can be given only by the person to whom the offer is made. What type of acceptance is that called? What type of offer? Specific offer. Acceptance must be absolute and unqualified. Counter offer. Acceptance must be communicated. Brogden versus Metropolitan Railway Company. In this case, what happened? The manager said, we accept. And he kept that letter in the drawer only. It was never posted to the other party. Just the way offer must be communicated, acceptance should also be communicated. Next one is, acceptance must be in the prescribed mode. What do I mean by that? If I tell you, you have to send me an email, you have to send an email. What if I reply to you on WhatsApp? Is it a valid acceptance? There is one more condition you need to add. It is not a valid acceptance provided you communicate it. Sir, I have clearly told you have to write an email and we do not accept WhatsApp. If you do not communicate it, it is considered as valid acceptance. There they will question. Agreed? Yes, sir. Okay, next one is time. Acceptance should be within the given time. Mere silence is not acceptance. Feldhaus versus Bindley. Horse. Uncle said, keep away that horse from the auction. Hello? If yes, you should taka tell. If you should keep going forward. Acceptance by conduct or implied acceptance. Acceptance can be express or implied. Communication of offer and acceptance. How is communication of offer? When is offer and acceptance complete? Offer is complete when offeree gets to know of the offer. When is acceptance complete? Two people are required. One is from the proposer's point of view, one is from the acceptor's point of view. When is it completed from the proposer's point of view? So whenever he writes a letter and he puts it in the course of transmission, that is when the acceptance is complete from the proposer's point of view. For the acceptor, when is the acceptance complete? Whenever the proposer reads it is when the acceptance complete. We have spent enough time when we were doing that. Remember, next one is people, what is that? Special conditions. Special conditions, is it valid, invalid? What is the scenario?
Sir, as long as they are reasonable.
As long as the conditions are reasonable, any terms and conditions written on a ticket, banner or wherever it is, all of that will be binding on you as long as they are reasonable. If they are unreasonable, it will not bind you. Case law we saw here, people, was Lily White versus Manuswamy. And next one we saw was people, what? Whenever there is a contract on a telephone, whenever there is an acceptance of a telephone, wherever the acceptance is heard, that is what will be considered as a place of contract. And next one, whenever the line is not clear, it is your duty to call again and re-clarify everything and then enter into a contract. That's acceptance. The last one's a revocation of offer and acceptance. First one is by notice, clearly tell. Second one is by lapse of time. Within time, if you don't do it, it is done. By fulfillment, non-fulfillment of condition precedent. I said the free delivery, provided it is within 150 rupees, 200 rupees, you did not do it, it's not there. By death or insanity, the person, whoever has given the offer, that person only dies. Provided it should have not been accepted yet. What if it is accepted? Offer is accepted means then death won't death is not a reason for revocation of a contract. The contract will continue as long as it does not involve personal skill. Yes, if the contract is for someone to sing, personal skill is involved. Death, yes, contract becomes void. What if there was a loan agreement? Death does not affect the contract. Contract will continue. The legal heirs will have to repay it if it is accepted. If it is not accepted, it will come to an end. Next one, counter offer we already saw. By non-acceptance the offer according to the prescribed or usual mode. I sent you email, you wrote WhatsApp. By subsequent illegality. What is subsequent illegality called as? Subsequent illegality. What type of contract? What type of contract? Subsequent illegality.
Void. If we
Void contract. Void contract. Subsequent illegality. When you enter it as legal, subsequent it is becoming illegal. So you consider it as void contract. Done? Yes, that is your unit 1. What took us 2 days? Took us 20 minutes now. What if you do it every day? Correct, no? See, power of mind. Okay. Next one, people, is consideration. What is the definition of consideration? Macha, most asked definition oriented question is consideration. No? So, ratta mar and go. When at the desire of the promiser, promisee or any other person does or abstains from doing. Does not tilde promises to do or abstains from doing. Such act or abstinence is called as consideration. Okay. First thing is you need to see, you arrange that, people. Does, done, promise and all. Remember 3 things. Put it in past, present, future. First one is already done. So past, done or abstained. Past, done. Does or abstains in the present, going on. Whenever I use the word promise, that means reciprocal promises. So I am using it for the future. So promises to do or abstain from doing something.
So we can say that promise and performance that are exchanged with the other party, between the parties, is what is consideration.
When you are writing definition, you are required to write this only. Yes, sir. Okay, so when at the desire of the promiser, promisee or any other person does or abstained, done or abstained, does or abstains, promises to do or abstain, that is only called as consideration. For all of this, there was a case law. What is that? When at the desire of the promiser, what are the case law? Rules of consideration. What is the case law? Durga Prasad versus Baldio. Shop case. Commission plus rent. Why should I pay commission? Rent is for using the shop. Why commission? I did not ask you to build the shops for me. Durga Prasad versus Baldio. So when at the desire of the promiser, promisee or any other person, what is the case law? Chinnaya versus Ramaya. Consideration need not move from me. It can move from third party. Any other person also is valid. Correct? And consideration can be past, present, future. Yes, sir. So this is only called as your rules of consideration also. Consideration should always move at the desire of the promiser. Consideration can be past, present, future. Consideration can move from promisee or any other person. I only need not give. Example, Chinnaya versus Ramaya. Uncle got pension from the lady, but uncle's sister paid or gave the land. So I did not give, but she gave. It is still a valid contract. Agreed? And next one is consideration need not be adequate. So consideration must move the desire of the promiser. Consideration may move from promisee or any other person. And consideration can be past, present. Consideration may be executed. Consideration need not be adequate. And performance of what one is legally bound to. Now you know how many questions you saw here. So when I tell you in the class this concept is important, now you have written all the, at least by now you have written some tests, no? You know how they are asking the questions, no? That's how I tell after seeing the papers, people, this is the topic where they are asking more questions. Focus. Understood? Important. What is the thing we saw here? Performance of what one is legally bound to perform. firefighter, fire engineer, police officer, doctor, it can be an advocate. After winning, I want extra money. All of this you cannot demand.
Sir, it can be government employees.
Government employee also, yes. Everything will come here. Whatever you are legally bound to perform, that you cannot claim it as a valid contract. Remember, hello? Correct. Consideration must be real and not illusionary. That means it should be possible to perform. Black magic and all not possible. Consideration must not be unlawful, immoral, or opposed to public policy. What is that? We will see it in Unit 3. What are those things? Opposed to public policy and all. Sued by a third party to a contractor. Now, people, whenever A and B enter into a contract, can the third party go and file a case on them? Is it possible? Technically, no, not possible. This concept only is called as doctrine of privity of contract. This was seen in the case law Dunlop pneumatic tire versus Selfridge. Hello?
Yes.
Dunlop pneumatic tire. You're not supposed to sell the tire for less than a particular price. This condition was told to the manufacturer by wholesaler. Wholesaler also told it to retailer, but retailer sold it for a price lesser than the agreed price. Hello? Okay. Exceptions to doctrine of privity of contract. That is, in general, people who can file a case, people only parties to the contract can file a case. But for this, there are exceptions also. What is that? In the case of trust, beneficiaries can file. The best example we saw was in your colleges. Someone has created a trust. Someone is taking care of the trust, but the trust was created for this benefits the students. So if students wants, they can still file a case. Second one, in case of family settlement agreement. Family settlement agreement is nothing but any party, any property dispute settlement. Whether your name is there in that document or not, you still are entitled to go and fight. Family settlement agreement. That is where we had seen great grandfather and all. In the case of marriage contracts or arrangements, for whosoever benefit the contract is made, they have a right to come and fight for it. Example was that, if you remember, I told Khwaja Muhammad Khan versus Hussaini Begum. I told you, if you remember. Khwaja Muhammad Khan versus Hussaini Begum was correct, 500 rupees wala. The father-in-law had promised the father that if your daughter marries my son, I'll give you 500 rupees. So the daughter married the son, but the father-in-law did not pay that father 500 rupees. Later on, the daughter-in-law filed a case on the father-in-law. You have promised to pay 500 rupees to my father, please give it to me. He said the contract was between you and, me and your father. You are an outsider, you cannot file a case or you cannot interfere. When the matter went to court, the whole contract was made for their benefit, so they could interfere. That's what is the scenario.
So in the case, only the person who's getting the benefit can file.
Correct. So basically it will be the bride or the groom.
Yeah.
Next one, in the case of assignment of a contract. Assignment means nothing but people, we saw difference also. Difference between assignment and transmission. I made you write one note as well. What is an assignment? Assignment is nothing but, I made you a note also. Assignment is what? Assignment is nothing but transfer. Can I transfer benefits? You had to pay me money. I'm telling, instead of paying me money, you pay money to him. Can I transfer this right to someone? Yes. I need to pay you money. Can I say, can I transfer this to someone? Instead of me paying money, I'll tell Nitin to pay money. Is it allowed? You can always transfer benefits. You can never transfer liability without everyone's consent. Everyone's consent is required. Hello? Yes or no? Okay. Next one is acknowledgement. What is acknowledgement? I stop Allah 100 times we have seen. Once you have agreed something, you cannot step back. You cannot go back. Example was me trying to sell Ramana's phone in front of Ramana. If Ramana had stopped me, well and good. But I auctioned Ramana's phone in front of him only to the class. Did Ramana stop me? Answer is no. So, Ramana cannot stop this contract in the future as well. Yes?
So we have a case law, Chinaya versus Ramaya.
Estoppel or acknowledgement, Chinaya versus Ramaya will also come because she agreed she cannot step back. In case of the covenant running with the land, did you see a question?
Seller, yeah.
We had a question also.
That condition.
Successor, we had it, right?
Yeah.
In the class test, I think there was one. I think so. I'm not sure. Covenant running with the land. I remember giving it. Okay. Yes. Whenever I have imposed a condition that when whosoever is buying the land from me, they are not supposed to use the land for a particular purpose. No matter how many times they sell the land, B sells it to C, C sells it to D, D sells it to E. Now A has not entered into a contract with all those people, but still law protects it. This applies only in the case of a land. That is only called as covenant running with the land. When I said A has said B, you're not supposed to use this land for the purpose of industrial activities. If I've clearly told, you're not supposed to do that. What if B sells it to C? C is not supposed to do that. C sells it to D. D is not supposed to do that. I don't have a contract with any of those people, but still you're not supposed to carry that. That is what is called as covenant running with the land. The condition you have put that keeps on running with the land of how many ever transfers you make, it will still run.
Sir, if there is a specific time period after that,
you can use it. That is fine. Yes. In Indian Contract Act, that is not prescribed, but I tell you, right, Transfer of Property Act, in that they have prescribed. You cannot have this condition forever. Then this transfer becomes invalid. Because that means when will he enjoy the property? So you should always have a condition for a certain period. That is there in Transfer of Property Act. Seventh ones are contracts entered through an agent. Possible, that time I would have said people will do people in Unit 9. Nitin thought, sir, we skipped it. No. Okay. So contracts entered through an agent. Valida, invalida. Why did we see here? Because agent is entering into a contract with a third party. Now, who is a outsider? Principal is an outsider. Can principal interfere or not? Yes, possible. Because for my benefit only, you are entering into a contract. Now makes sense? Yes. See, if not, if I explain it there only, you see the time that we need to put. Correct? Okay. Validity of an agreement without consideration. Now see how important section 25 is. Hello? Yes? Now go back and see. What is that? Sir, whenever general rule is that quid pro quo, consensus ad idem, there has to be give and take. But even if there is no give and take, in certain cases, the contract will still be valid. What is that? First one is people, natural love and affection. A father transferring his property to a daughter. Father is giving property. Daughter, what is she giving? Daughter is giving natural love and affection. Provided there are three conditions you need to satisfy. What is that? This has to be in near relationship. It has to be in writing. Mandatorily to be registered. Next one, sir. Compensation for past voluntary services. I find a purse. I only voluntarily go and give it back to the required person. Then he promises to pay me 5,000 rupees for being so honest and a good citizen of this country. He promises to pay me 5,000 rupees. Once he promises a cash reward, that becomes an enforceable contract. That only is called as compensation for past voluntary services. Sir, what if he not promises anything? Can I enforce it? No, you cannot enforce it. Then what can you do? You can retain the product with you. Remember that. If he doesn't give you the money, you can retain the product with you. Can I sell the product? Yes?
He didn't give money.
Then I can sell it. You do not forget it. I can sell it only in two circumstances. One, when the owner is not found. Next one, owner is found. And we wrote two conditions. What? The goods are perishable or 2/3 of the product's value is what I incurred to find the owner. Then I am telling there is no point in having it, sell it. Simply you should not sell, you should sell it. You have to wait. Hello? Yes. Next one. Promises to pay a time bar debt. Understood now? Done. 3 years done. I again write I will pay. I have to pay. Agency. Correct? No consideration is necessary. Agreed? A parent can appoint his daughter or son or anyone also as an agent. I need not have to pay for it. It is still a valid contract. Yesterday we saw. Next one is completed gift. Bailment. Now tell me, what are the two types of bailment? Gratuitous bailment, non-gratuitous bailment. Gratuitous, free only, no? That is what they are telling. Charity. When will charity become a valid contract? whenever I promise to do something based upon my word, the other party has taken up a liability. Now, people, I cannot go back. I have to give the promised amount. Example is, there is a person who is raising funds for a person, a small child's operation. So I said I will pay you money by end of this month after I getting my salary. Now after 1 month I saw people, they have collected good amount. Now I do not want to go ahead. So can I now take back my promise? It depends. What if this person has gone and admitted the child in the hospital? Now the operations are undertaken. Now a liability has already incurred. Now whatever I have promised, I have to give. I cannot take back the amount. I cannot take back my words. So charity becomes a binding contract if the other party has taken up a liability. If the other party has not undertaken a liability, you can withdraw.
Actually, the incident has happened.
Correct. The not even incident. You need to write the word, the liability has been undertaken. That means I have admitted for operations. Our operation need not be conducted. But admission is also a good thing for me to enforce a contract. Clear? Yes, sir? Done. That's your consideration. Okay, next one, other essential elements of a valid contract. Okay, other essential elements, people, what is that? First one was competent. The parties has to be competent. That means what? The parties has to be, first thing is major. That means you should have touched 18 years. So what are the rules of minor? A minor agreement, people, is always considered as void ab initio. So any agreement with a minor, it's always void ab initio, invalid from the beginning. Case law, people, Mohiri Bibi versus Dharmodas Ghosh. Next one, people, no ratification after attaining majority. So whatever is a contract you entered while you were a minor, after you become a major, you cannot again make it valid. Whatever is the past, you cannot again make it valid in the future. Now see how many times you saw ratification. Yes. Next one, minor can be a beneficiary. Anything incoming allowed, anything outgoing not allowed. Partnership, minor can become a beneficiary, allowed. Next one, minor can always plead minority. I will enter into an agreement. Later I will say this is not enforceable. The law will listen to you. Next one, liability for necessaries. Any person who has spent money on you for necessaries, you are liable. Sorry, your property is liable. Hello? And we saw one more point also. Where did we see this?
Civil law.
No. This liability for necessaries. Where did you see this? Recently I explained you. Huh? Yes, so from correct. Quasi contract. Whenever any contract, whenever you have supplied anything, necessaries to an incompetent person, whether it is a minor, unsound mind, or any person dependent on them, you have a right to recover it from their property. We saw that. Both are the same things. Hello? What is necessary? Something which is required, not lavish, not luxurious, and the person should not already have a supply of it. Then I can enforce it. I told you example also, Noda. In Karnataka, transportation is free. Now it is already covered. Again, if someone is giving money for it, it will not become necessary. Hello? Yes or no? Okay. Next one, contract by guardian. If a minor has to enter into a contract, you can enter into a contract through a guardian. Best example, your education and all. A minor can never become insolvent. You cannot enforce specific performance. Minor can be a agent. Now understood this, huh? You would have seen there, we will see later. This is the rule. Understood? Minor can be an agent provided if minor does something, the liability will always be on the principal if it is beyond his scope. Hello? Now you see, when can agent be held liable? Incompetent principal and all that will come. You remember? That's where again we saw this one thing. Correct? And one more thing we saw was who can be a principal, who can be an agent. In that we would have seen. Okay. Minor cannot bind parent or guardian. I cannot go and bind the parent or guardian. I cannot say my parent will come and pay the money. Parents are not liable. Next one is people joint contract. Whenever a minor and a major together has borrowed the loan, minor is not liable, but major is liable to repay complete money. Where else you saw this? Joint promisors. Surety as a minor. Where else you saw this? Indemnity contracts and guarantee contracts. In guarantee contract you saw this. Can a surety be a minor? Is it possible? Surety cannot be a minor, but can a principal be a minor? What if a major is a surety and a minor is a debtor? Minor has borrowed. Surety is given by a major. Is it allowed? Minor has borrowed the loan. Who has given the guarantee? Major is given. Adult has given. Is it enforceable contract or not? Yes, it is enforceable contract. That is what they are telling you. Anyone who has given a surety for a minor, such person will be liable. Minor will not be liable. Agreed? Can a minor become a shareholder? Directly, no. But you can do it through guardian, provided it has to be a fully paid shares. Liability for torts. Tort means people, civil wrong. Like defamation, you abuse someone, for all of that you are liable. Only for contracts you are not liable. Okay, next one people is a person of sound mind. So you should not be unsound mind. Unsound means people, a person who is intoxicated or a person who is unstable. Now these people cannot enter into a contract when they are unstable. But when they are stable, they are free to enter into a contract. Yes, next one is contract by a disqualified person. Following people are disqualified. Who are they? One is foreign sovereigns and ambassadors. See, just as we speak, Anna has done something. He has launched a war on Iran. Just now, as we speak, you should see that 8-minute speech he has given. If there is a modern way of giving a threat, how you just see that 8-minute video, how he has said. There will be casualties, and he is saying it is for a greater good. People will die today, and he has clearly said, we are requesting the residents of Iran, please do not step out, and it will be all bombs shredded throughout your city. Do not step out today. And he has said, you should see the video. Just 2 hours, one and a half, 2 hours back, they have said, we are launching a war on Iran. And first missile is also hit. And he has clearly said, do not step out. And this is the warning to all the police as well as the military people. If you stay on ground, you surrender, you live. If not, you die. And today is the day where you see that the long started war ends. Yes? See? Power. You cannot enter into a contract with foreign Beka, Ramana entered into a contract. That is what we had seen example, I think, no? So you are not supposed to enter into a contract. Alien enemy, the country with whom we have a war. You cannot enter into a contract with such people. Insolvent, disqualified. Convictor, the person who is arrested and proven guilty. As long as they are in the jail, you cannot enter into a contract. Corporations, we are yet to see. When we see, we'll see what it is.
Beyond the scope of MOA.
Correct. Concept of free consent. What do I mean by free consent, sir?
Without any.
Correct. So we have in total 5 things. Here only I'll revise off. Coercion. What do I mean by coercion? Coercion is nothing but when a person is doing something. See, in all of these people, your acceptance is not taken free. Free means people, I am pressurizing you to say yes. But in different ways. Correct. So now whenever there is a coercion means what? I'm pressurizing you. I'm pushing you to say yes. But I'm using people, some illegal means. That is, I'm using some means which is not agreed in IPC. So if I do anything which is forbidden under IPC, brackets write IPC, but in the mainstream write BNS 2023, which is forbidden there, if I am doing any such act, people, is considered as coercion, murder, theft. Any act punishable under BNS or anything which is forbidden under BNS. Brackets write down IPC. Yes, So if we are doing that is called coercion. Any such contract is considered as voidable. Remember, what if I go to court, I get back my property. Whatever is a benefit you have taken, it is your duty to return back the benefit as well. Agreed? Okay, that is coercion. What is undue influence? There is always a bond sharing relationship between the parties, and always there is a person, one person in dominant position, one person in inferior position, and the dominant position always takes advantage over the inferior position. In such case, people, the person, if he says there has been an undue influence on him, if he can prove, then the burden of proof saying there was no unfair advantage should be always on the person in the dominant position. Burden of proof you would have seen. That is only called as undue influence. Difference between coercion and undue influence.
There is one major difference. Third party is involved in coercion.
Coercion
Correct.
Third party is not involved.
Yes. So the difference between coercion and undue influence. Coercion, it is always me or through any other person. I need not threaten, shoot myself. I can show gun through someone also. But in case of undue influence, it is only two parties. And next difference is, people, here coercion, if I make the contract as void, I have to return back whatever benefit I have taken. In undue influence, people, it is subject to the order of the court. Court can tell you to repay entire money, repay half money, don't pay also. You will go with what court orders.
And then in a coercion, there is no dominant or
No relationship.
no relationship.
It can be anything. Here it's always you have a dominant position.
With an unfair advantage is taking place from the dominant person.
Sir, here you are not punishable under business.
Yes, here coercion is to do something which is forbidden under BNS, for which there is a punishment for you. Imprisonment or jail or capital punishment, or there is something. In undue influence, there is nothing. Okay, next one is, people, fraud. What is fraud, people? Is mere silence a fraud? Generally, no. Because KVA tempter will apply. That means what? You guys have to also check. But there are some instances where even if you are silent, people, it will be considered as fraud. What is the case? When silence is considered as an acceptance, is considered as speech. Next one, you have a duty to speak. Duty to speak is like fiduciary relationship. When a father is selling something to a son, son believes that the father would never cheat. Even if you keep quiet, it is considered as fraud. Understood? Yes, sir. So that is fraud. Fraud, people, in every case we have written voidable, but here alone we have put asterisk mark. Why? Because in fraud case, I have three remedies. Remedy number one, I can cancel the contract, ask back the money. Remedy number two, I can ask you to put me in the place which I would have been if fraud did not take place. That means you gave me a furniture which is broken. Put me in a place which I would have been if furniture was not broken. That means you have to supply the same furniture or repair it and supply it to me again. Second remedy. Third remedy, I can always claim compensation here. Here and all we did not see that. Here you are eligible to claim compensation. Hello? Yes or no? Are you going up? Hey, letter by letter, I am not skipping one word also. I don't know if you guys are understanding. I am only telling you the keywords. I am not telling the entire story. If you are able to remember that, sufficient. Yes? Okay, misrepresentation. What is misrepresentation? Not knowing it to be true.
It's a positive assertion.
Positive assertion of a fact, believing it to be positive and not true. That is only called as misrepresentation. Misrepresentation is also a voidable contract. Remember, people, you have a right to cancel the contract, but you have a right, you also have a right to, if the other party wants to say fix the repairs or fix the damaged product, if you accept it, and later on again if some damage happens to the product, you cannot cancel it. Once you will have a right. On that part, people, there will be question. Remember it. You will have a right to return it only once. If you accept it once, you will lose a right to do anything. Understood? Yes, sir. Okay. Next one is called as, people, mutual mistake. People, remember, mistake can be of two types. One is called as mistake of law. See, try to remember what you've written only. Mistake of law, mistake of fact. Mistake of law can be further classified into two. Mistake of Indian law, mistake of foreign law. Mistake of Indian law will always be treated as valid agreement. Who cares if you ignored? In the eyes of law, it is valid only. Next one is mistake of foreign law. Mistake of foreign law is treated as mistake of fact. That is, you will treat it as void. Next one is mistake of fact. Mistake of fact can be further classified into unilateral mistake, bilateral mistake. Unilateral mistake will be classified as
Void. Valid.
Valid.
unilateral mistake is considered as valid because you ignored it. One party is under a fixed thing. Example for this is don't just mug it up. Unilateral mistake is nothing but I order something on Amazon. On the contract, it is clearly written I have ordered for this particular product, but you end up getting some other product. It's a mistake from Amazon, not from your end. You knew which one you want. That's called as what? Unilateral mistake. Bilateral mistake means people, both of us are under a mistake. The best example was I asked Ramana, would you want to buy this mic? Ramana thought he wants to buy this mic. There is a difference here. But what did I say? I want to sell my mic to you, Ramana. Hello? Now, mic are of two types. That's why I told you bilateral mistake can also be considered as it's a void. You can also treat it as people uncertain. Offer has to be certain and not vague. Now I need to say which mic. I'm telling you I have two cars. I'm telling you I want to sell my car. Which car? It becomes uncertain here. Red car. Understanding? Or which brand? However, as the case may be. Understood? Mutual mistake. Okay. That will be considered as void. Okay, done. Next one is mistake is done, na? Okay. Legality of object and consideration. When do we say that the objects are unlawful, people? When it is to do something which is forbidden by law. What is that? Which are punishable under any statutes. If I do anything like that, it is considered as forbidden by law. Next one is when consideration or object defeats the provision of law. Meaning me telling that minor agreements, the restriction on minor agreements is not applicable to our contract. If I defeat the purpose, such agreements are void. Next one is when it is fraudulent, smuggling and all of that. When consideration involves injury to a person or a property. I give you money to go and kill him, or I give you money to go and destroy his property. It is considered as unlawful. When consideration is immoral. Immoral is nothing but there is nothing written on it in the law, but we consider it as a society, it is not good. That is called as immoral. I gave you an example also. One person giving money to another person to divorce. Someone influencing to give negative comments on someone. All of this, nowadays it is becoming a big thing, right? Next one is consideration opposed to public policy. What are the consideration opposed to public policy? One is trading with alien enemy. Next one is stifling of prosecution. What do you mean by stifling of prosecution? Nothing but stifle means what, people? To make a trade. Stifling of prosecution means what? You cannot make a trade of your prosecution. Generally, meaning what, people? You cannot settle these matters. You cannot make a trade of felony. You cannot settle the crime. So I told you there are two types of offenses. One is called as compoundable, one is called as non-compoundable. So compoundable offenses you guys can compromise. Non-compoundable offenses you guys cannot compromise. Imagine A kills B. B's family cannot go and compromise with A. You have to take it to court. That is called non-compoundable. Compoundable means what? You hit someone's car. Normal accident. Even if you go to court, court will tell you to pay money only. That you pay here only. It's a compromise. It is allowed.
So we can say that mainly compoundable or all are civil matters. And they are
Yes. Compoundable is 100% civil matters only. Clear? Okay. Next one, maintenance and champerty. What do I mean by maintenance and champerty? Whenever one person helps another person to file a legal case, expecting something in return or not, is called as maintenance and champerty. So I am helping A and B are fighting. A doesn't have money. I help A to go and fight a case on B. I'm giving him some money. Now, what do I want in return? I may want something in return. I do not expect anything in return. Such type of things are called as maintenance and champerty. Sir, this sounds good only. Now, why is it unlawful or why is it opposed to public policy? It is opposed to public policy if it becomes a what? Unreasonable, or the help is done because of malicious motive, bad intention. Now, a person is helping a party. Now, what is he expecting in return? Imagine if it's a property matter. I'm telling, if you get 1 crore, in that I need 50 lakhs. That's why I'm helping you. Unreasonable help. It becomes opposed to public policy. Next one, why am I helping you to fight a case on him? Because I don't like him. That's why I'm giving you money to fight a case on him. Such things are also considered as opposed to public policy. So maintenance and champerty by default are not opposed to public policy. If the intention is bad or the return expected is unreasonable, it becomes opposed to public policy. Malicious motive is the word you guys have to write. Hello? Next one, trafficking related to public office and titles. What are the example we saw? Trafficking. Public office, dad, you want to become commissioner? Want to become chief commissioner? Titles, sir, give me, sir, one Padma Bhushan. Take 5 lakhs. Ravana? What about Ravana? Agreements creating a monopoly. What is this? Give me example, Ramana. Agreements creating monopoly. Ramana? 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 Physically present. Mental? Psychologically absent. Why da Ramana? Enna achu Ramana? Okay. Agreements creating monopoly. Imagine Jio and Airtel coming together, or anything, any such big chains coming together will always kill competition. Marriage brokerage agreements I've explained in class, people. Bureau, marriage bureau is different, marriage brokerage agreement is different. Marriage bureaus are valid because they just give data. They are not encouraging you to marry him only. I like that purple shirt fellow. I want that they are not telling. Agreed? Okay, next one, interference with course of justice. What is this? People, this is what you saw. Interference with course of justice. One case was there in class test. You give money to the opponent lawyer not to take up any case. If I'm not wrong, something on with regards to Manoj was there. A person gives money to a lawyer saying that you should not take up that case. That's why he does not take it up. That is only called as interference with course of justice. What do I mean by that? I bribe any judicial officer. I bribe the witness. I bribe the lawyer. I bribe the judge. You cannot stop the prosecution. You cannot stop a case. Yes, interest against obligation. What is this interest against obligation? A government officer has to select a raw material supplier. He has to select such raw material supplier which is good for the government. That means least bid. But which one will he approve? Whichever gives him the highest commission. So he is creating an interest against his duties. That is example. Consideration unlawful in part. Wheat and weed. Wheat is enforceable. Weed is non-enforceable. Done. Void agreements. What are the next void agreements, people? Agreement in restraint of marriage. Salman Khan took money and said, I will never get married. Even if that is a condition, you can always get married because such agreements are considered as void. Agreements in restraint of trade. We saw so many conditions. Now you saw so many questions also. Now you think important or not. If yes, go and remember the section. That is how you need to do. Hello? Are you getting the point? So no one can stop you from doing a trade forever. Reasonable restriction is valid. Now what is reasonable? For a certain time is reasonable. Only in one area. reasonable.
Same product.
Same product, reasonable. Sir, forever, unreasonable. In anywhere in India, unreasonable. Don't do artificial jewelry, original jewelry. Unreasonable. Whatever is a business you sold, you're not supposed to do that only. No, you cannot stop me from doing everything. Hello? Okay. Agreement in restraint of legal proceeding. A question was there. Two parties have agreed not to go to court. Class test was there. So even if a contract says you are not supposed to go to court, such clauses will be treated as void. Agreement, the meaning of which is uncertain. We have already seen wagering agreements. Wagering agreements are taka tell off. In wagering agreements, what and all was there? A event which is uncertain, something which depends upon a collateral event which is uncertain, which may happen or may not happen. Agreements which are similar to wager. Section 30. What are the agreements similar to wager? First it starts with lottery. Lottery transactions. What is the transaction? Lottery transaction. Legal, void, illegal. What it is? Illegal in India. Correct? What if government only is conducting the lottery? Then it is still illegal only, but not punishable. That is what you saw in lottery. Next you saw was crossword puzzle. Crossword puzzle, tell me, is it legal or illegal?
So it depends on the price.
Depends upon the price and skill. If at all the prize money is dependent upon luck, it is considered as wager. If the prize money is dependent upon skill, it is considered as valid, provided the prize money does not exceed 1,000. Next you saw was speculative transaction. Share market transactions are considered as valid, provided you guys are doing it as per the law. Within the outside is invalid. Within the share market, valid. Fourth one was horse trade.
The price bidding is invalid, right?
That is invalid.
That is considered as speculative transaction.
Price rigging. Yes, 100%. Yes, sir. Fourth one is horse race. What is horse race? Whenever the prize money more than 500 is valid, less than 500 is invalid. Yes, sir. Next one, sir. Contract similar to wager but still valid. What were that? Chit fund, share market, game of skill, prize, skill and competition. Next one was contract of insurance. Now we saw difference. Contract of insurance and wager. We saw in the insurance contract, if you remember. Hello? That is your wager. That's your unit 3. Then hello? Okay. Unit 4, performance of contract. Who can perform the contract? A contract can be of two types. One is actual performance, one is attempted performance. Actual performance is when both the parties have performed their obligations. That is why it's also called as executed contract. Attempted performance means what? One party attempted but the other party refused or did not accept the performance. That is only called as attempted. Remember such cases, people, the person who attempted the performance is free from obligation. Now it is your duty. Whoever attempted, he tried doing his obligation. You did not accept it. It is your headache now. Agreed? Yes. Yes, if he wants, he can end the contract. Flipkart tried to deliver you the product. You were not there at home. This is only called as what? Attempted performance. Agreed? Yes. Effect of refusal of party to perform. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he had signified by words or conduct his acquiescence in its continuance. What is this? Remember, if a singer said he will be performing for a certain period of time, if he did not come, I have a right to put an end to the contract. However, unless he has signified by words or conduct, some other singer came, he agreed.
He did not tell anything.
Third week he did not come. Class test question. Fourth week he came. I did not tell anything. That means I'm accepting. I can claim compensation for third week, but I cannot cancel the contract. Question was there. Class test.
Something.
Correct. That's Sonu and Mika.
No, not
Mika. Yes, conditions to be satisfied for okay, reasonable opportunity examine. Okay, by whom a contract may be performed. Who can perform the contract? First one is promisor himself. Whenever the contract clearly says you should only perform, whenever there is skill, talent, or contract specifically it says you should perform, then you should only perform. Sir, what if it's the case of death and such scenarios when there is no personal skill or talent involved? It is the responsibility of the legal representatives to perform the contract. Next one is agent. Correct? Now understood? I can do or I can tell an agent to do. Fourth one is third person. Sonu had to go and sing. Sonu sent Mika. Agreed? So if you accept it, well and good. We don't have a problem. Chinnaya versus Ramaya. Consideration need not move from promisee only. It can move from any other person, third party. Just that later on again I cannot enforce it. Again I cannot enforce it against you. Yes or no? Mika performed it. I cannot again enforce it on Sonu if you have accepted it. We saw it in the case of that Sonu versus Mika. Okay, joint promisors. Tell me the rules of joint promisors. Whenever 2 or 3 parties have taken a loan, now we have to repay.
Jointly liable.
You have to jointly liable. What if any person becomes insolvent?
Both the parties take loan.
The other joint promisors are liable to repay the whole consideration.
So that is subject to access.
No, insolvent.
Insolvent is different, death is different.
If at all insolvent, then other joint promisors have to share the loss. If at all death, then the legal representatives along with the other joint promisors will repay the loan.
So up to the limit of
Assets inherited. Next one is people, whenever any one joint promisor is excused. Ramana's uncle said, Ramana, you go. In such case, you are discharged from only the promisee's point of view, but not to the other joint promisors, you are liable. And next one is people,
end on the due date, promisee can force one promise.
correct. On the date of maturity, if you have not repaid the loan, the promisee can recover the whole of the debt from one person. Later, he can recover from others.
Joint promises.
Yes. Next rule was people joint promisee. Same cut, copy, paste. What is that? We can recover it in case of death. The legal representative along with the living joint promisees will recover the debt. That was joint promisees. Okay, liability of joint promise and promisee done, rights of joint promisees. Okay, time and place. Time and place for performance, we had clearly seen this. If time and place is specified, you have to clearly perform the contract in that place at that time. What if time and place is not specified, but the condition clearly says, if you make an application, I will come and deliver. So it is your responsibility to make an application. What if time is not specified, place is not specified, even the condition is not agreed?
So either of the party.
It is the liability of the promisor to ask where to deliver, and I have to deliver it within business hours. Correct? Okay, next one, sir. Performance of reciprocal promises, sir. Easy ones. I think one example was there also here. One class test was there. Promiser not bound to perform unless a reciprocal promisee is ready and willing to perform. That means what? Reciprocal.
Land property.
Correct. The reciprocal promise means what? Whenever I have ordered something on Amazon for cash on delivery, he is agreeing to deliver after 3 days. I am also agreeing to pay after 3 days. Both of us have agreed today. This is called as reciprocal promise. Executory bilateral. Now, first rule is one person need not perform. I need not pay if he does not deliver a product. He need not deliver product if I do not pay. Not only that, I cannot compel the other party to perform. If I fail to perform my obligation, I did not deliver the phone, I cannot tell you to make the payment. That is the second rule. What? Liability of Allah. Where is that? Where is that go?
So there is the second one.
Okay, I'll tell you. Order of performance of reciprocal promise. Who should perform the? Go as per the contract. If nothing is given, people, go as per the nature of the terms. That is, for example, I told you construction. First you pay, then they construct 25%. Again you pay, again they construct. Yes. Next one is people liability of party preventing event on which the contract is to take effect. What is this? This can also be considered as people negligence. I told you, you come tomorrow. You remember electrician now. We said we will give raw material. The electrician came. We stopped him from performing the contract. What can electrician do? Electrician can claim compensation. He can even cancel the contract. Voidable. Effect of default as to the promise which should be first performed in contract consisting of reciprocal promises. What are these people? Other party does not perform, then I am also discharged from my performance and I cannot compel you also to perform. That is what we saw.
So without making reciprocal promises, we can't force any of the party.
Until he is performing, you cannot compel me to perform. Effect of failure to perform at a time fixed in contract with where the time is
Voidable plus.
pink. Yes, sir. When time is essential, people, what happens, sir? The contract is voidable. You can also claim compensation. If time is not essential,
Not voidable.
contract is valid. You cannot cancel it, but you can claim compensation.
That is claim is that is to be given from the other letter. They can be voucher 100 rupees.
Correct. That's why contract is valid. You cannot cancel it, but they will give you some compensation. Can you guys tell me what type of compensation that is called? You cannot cancel the contract.
Involuntary compensation.
In nominal.
Very good. Nominal damages. Can you tell me what is the definition of nominal damages?
Proven that a breach of contract done, but not proven that loss are done.
Losses.
There is no
Now
any
put
loss
it in
except the
keywords. You have suffered a loss, but you have not, there is a breach of contract, but you have not suffered any loss. So the court, just to satisfy your ego, will declare some compensation that is called as nominal damages. It can be 100 rupees. In fact, if you look at your textbook, it says even 10 paise is also a nominal compensation. It is just given to satisfy your ego. Understood? See if you correlate. Hello? Okay. Next one, agreements to do impossible act. Can I do initial impossibility, void agreement. Subsequent impossibility, void contract. Reciprocal promises do certain things that are legal and certain things that are
illegal.
whatever is legal will be,
Valuable.
whatever is illegal is
Void.
weed and wheat. Alternate promises, one branch is being illegal. Same thing only, illegal part is always valid. Illegal part is invalid.
Void.
Appropriation of payment. What is appropriation of payment? Section 59, 60, 61. Remember, what is that? When a debtor has taken multiple payments, when I am repaying the multiple payments back to you. So if I have taken 3 loans, 1 lakh, 2 lakh and 30,000. Now, when I am repaying the loan, what is the order of repayment? The first thing is given to the debtor to choose. You choose towards what you want to repay. Debtor did not say anything. Second thing is circumstance. If I am exactly repaying 30,000, 30,000 says this is a circumstance that I will take it towards the third debt. So debtor also did not say anything. Circumstance also did not say anything. Then people, you will go with what? Creditor will be the second scenario. Creditor can choose in which order he needs to take it. If creditor also did not say anything, then you will go as per the time. FIFO, first in, first out. It will go in the same order. So you can also take it towards a time barred debt. Remember possible question. Section 59, 60, 61. Hello? 59 is debtor choosing. 60 creditor choosing. 61 time. First in, first out. Hello? Okay. Contracts which need not be performed. Which one? Section 62. Nothing but mutual agreement. In mutual agreement, you saw 3. Novation, alteration, recession. Novation is old contract replaced by a new contract. When that will happen? Whenever there is change in parties. Alteration, change in terms. Recession, cancellation of a contract. So these 3 contracts need not be performed. Next one was remission.
It is also similar to partnership. Right?
Which one?
Novation, alteration.
It will come. There also you may see.
So novation is the death and retirement. Alteration is the change in partnership ratio.
Correct.
Succession is dissolution.
Correct. You can see again the same thing will come in 2-3 places. It will come. So next one is called as remission. Remission means what, people? To give up my right. I had a right. I'm giving up my right. That is called as remission. I need not have to perform the given up part. The last one is people waiver. Last one is called negligence. When students when students do not read, a teacher is discharged from their liability. The next one is called as people discharge of a contract. When does the contract come to an end? By performance, mutual agreement, discharge, impossibility. Next one is declaration of war, alien enemy, discharge by lapse of time, time bar debtor, discharge of by operation of law, you become insolvent, discharge by breach of contract. That is nothing but when one party fails to perform. Next one is promisee may waive or remit performance. Waiver, effect of neglect, negligence, and merger of rights. What is merger of rights? When the tenant only becomes the owner. Merger of rights. Okay. I was a tenant. I've taken a property for lease for 5 years. In third year, I buy the property also. So at the same point of time, I'm a tenant as well. I'm a owner as well. So should
contract.
in the same tenure.
Tenure of period.
So in that case, any one contract has to prevail. Either I should be a tenant or I should be a owner. Whichever is superior will prevail.
Owner will be prepared.
I'll be owner and this will need not be performed. So this will come to an end.
Sir, until he becomes owner, the tenant contract will be performed. Right?
Correct. Rent I have to pay.
There is no certain compensation that has superiority came over that's been
The
discovered.
inferior contract automatically comes to an end. Okay, clear? Okay, next one, people. Breach of contract and its remedies. So breach of contract, people, anticipatory breach, actual breach. Actual breach is happening during the performance of a contract. Anticipatory breach will happen before the contract. Correct? Anticipatory breach, actual breach. The case law we saw here was Rochester versus De La Tour. And also one more, marriage. As long as the father is alive, I can't marry you. Yes. Frost versus night. Sir, okay. So anticipatory breach, I can immediately cancel the contract and claim compensation, or I can wait till the last day and claim compensation. But there is a risk of always the contract becoming void, factory becoming say breakout of fire. All that risk is always there. That means if there is a void contract, you cannot claim compensation. That compensation will also go off from your hand. Sir, next one, sir. What is the remedies available? What are the remedies available? These are the remedies available. First one is called as suit for damages. Under damages, what in all I can claim? First one is called as ordinary or general damages. That is nothing but whatever I have communicated, which whatever has naturally arisen because of the breach of contract. For that I am liable. Example in class test, the travels told you to get down, walk, go to a hotel, and we will take you in the next day. You are liable for inconvenience. You are liable for hotel charges. You are not liable for anything which is indirect. Cold and all, I am not liable. That is what is called suit for damages. Case law here, people, is Hadley versus Baxendale, crankshaft case law. Yes, sir. Next one is called as, people, second type of damages is called special damages. Whenever I have clearly given you specific instructions, I am liable for that particular specific instructions as well. I think we have seen multiple examples in your class test. Correct? Okay. Next one is third type of damage was what? Vindictive or exemplary. What is vindictive or exemplary? It is like a revenge. It is always given only in two cases. When? Vindictive, exemplary. When will they award?
Wrongful.
One is marriage. Whenever there is a break of marriage, that is when vindictive or exemplary will be given. Second one, wrongful dishonor of a check. That two types of parties are there. One is called as businessman. By default will get compensation. Next one is non-businessman. On proving will get compensation. The fourth type of damage is called as nominal damage. What is nominal damage? Nothing happened. You have not suffered any loss, but there is a breach. You will get some reasonable. The fifth one was liquidated damages. Nothing but prefixed damages. What is prefixed damages? Already the contract has said this is what the damages is going to be. That is called as what? Prefixed damages. Prefixed damages in Indian scenario has no further classification. But in the English law, there is a further classification. The prefixed damages can be further classified into liquidated damages and penalty. What is liquidated damages? A number that is logically arrived. And people, the intention is to compensate the parties. How about penalty? It is an illogical calculation, arbitrary number. What is the intention? To create terrorism, fear. So if you do not perform a 50,000 rupees worth contract, you need to pay a penalty of 1 lakh rupees. It creates fear. If you do not perform 50,000 worth contract, you need to give me 5,000 rupees compensation. It just gives you compensation. That's the difference between the word prefixed damage, liquidated damages and penalty. Remember, important. Okay. Deterioration caused by delay. The carrier will be liable. I can hold the carrier accountable. Hello? Okay. Next one, people, rescission of a contract. A party who, for example, time is essential. He has a right to cancel the contract. Later, I need not have to accept it. And claim damages. Next one, suit for specific performance. As suit for specific performance means nothing but people, whenever the property is rare, unique or of any special personal importance to the party, I can claim specific performance. That means A said B, I will sell an antique item to you. I cannot find an alternative to that. Only then the court will award specific performance. Hello?
Give the antique.
Antique only. Court will tell you have to give that. No money compensation. Next one is suit for injunction. What is injunction? Injunction is stay order. Whenever court wants to stop you, refrain you from whatever you are doing, I'll pass an order. Stop. That's called as injunction. Next one is called suit for quantum merit. What is quantum merit? When a party has not completely performed the contract, we stop the contract in between. You are eligible as long as you are not the wrongdoer. You are eligible to get some compensation for whatever you have done. So, quantum merit means to get money as much as performed. If I am to teach you 20 days, but because of something we end the contract on the 10th day, I am eligible to get my half payment.
Quantity specific.
Quantity is quantum. Merit is money. Merit is nothing but something in return or your compensation. So, quantity, compensation as much as performed. That is quantum merit.
Only one person is referring to performance, right?
Correct, yes. So, quantum merit also depends upon two types. One is it divisible contract, indivisible. Divisible means people as much as performed. Indivisible means people I can deduct some money for the bad performance you have done.
Reasonable money can be deducted and claimed for that.
Correct. We saw that painting of the wall. You have not painted the wall properly. I have to get someone else done that work. For that, whatever I incurred, that money I can deduct from the first painter. Yes, that is unit 5. Done. Next one, sir, unit 6. Contingent and quasi contracts. Okay, contingent and quasi contracts. What is a contingent contract? A contract which to do or not to do something, if some event collateral to such contract does or does not happen. See, a contract to do or not to do. Let us imagine a contract to do, a contract to pay some money if an accident happens. So, if some event collateral to such contract happens, so I will pay you money if something happens. That is like an accident happens. I am agreeing to give you money. So, best example is indemnity contract, insurance, guarantee contract, as the case may be. Correct? Okay. Essentials of a contingent contract. What people? 4 rules. When can I exercise the? What is that? Enforcement of contingent contract. Main 4 rules. What are the main 4 rules, people? When can I? Upon on an event happening within the prescribed time, on an event not happening within the prescribed time. And next one is based upon a conduct of a living person and an impossibility act. These are the rules of contingent contracts. Yes, sir. Okay. And the next one what we had to see was quasi contract. Correct? I hope that is clear here. That 6 rules. Ship, insurance, we have seen one class test also. Hospital says if you incur coronavirus within 3 months, we will pay you compensation. So, a contract exercisable upon happening of an event within fixed time. The hospital has to pay money because the doctor was diagnosed with COVID within 3 months. Hello? Class test people, I think you are able to recall. Correct, yes, the ship example and that. Okay, the features of quasi contract. What do I mean by quasi contract? Quasi contract means it's not an actual contract, but it is a contract. It's similar to contract. So, what are the cases deemed as quasi contract which we have already seen? I already said. People, remember the section here, important. 68. Claim for necessaries supplied to incompetent person and person dependent on them. Too many times I have asked that. Payment made by an interested person. What do you mean by interested person? People remember multiple times I have asked this also. What do you mean by this? Payment made by an interested person. Our landowner should have paid electricity bill. He did not pay. Arivu, because we also have some interest. If not, they will take away fuse and they will go. So we paid the electricity bill. Technically, owner should have paid. Now, can we recover that money? Answer is yes. Even if there is no contract between us, I can recover the money. That is the meaning of payment made by interested person. Obligation of a person enjoying a benefit of non-gratuitous act. Ramana eating that dosa example, if you remember. No one means to give you a dosa for free of cost. That too in Swiggy within 20 minutes, hot dosa. Who will give? So, if you have taken a benefit of it, you have to pay for it. Responsibility of a finder of lost goods. Section. Correct. Money paid by mistake or under coercion. You saw coercion. If you have given coercion, quasi contract, you have taken back the product. It is your duty to pay back the money. Correct. Next one is mistake. Money paid by mistake or coercion. Mistake is what? I had to pay 20 rupees, but by mistake I have given 200 rupees. It is the duty of other person to return the excess paid. Then this is your quasi contract.
What is the section of payment by interested person?
Payment made by interested person is 69. Clear, done? Hello? Yes? Okay. Unit 7, Takatak, we'll do it off. Indemnity contract, people. People, first thing, indemnity contract, who are the parties in indemnity contract? Indemnifier, indemnity holder. Indemnifier is the person who has agreed to make good the loss. The word has to be this only, the person who has made good the loss. Indemnity holder is a person who is agreed or entitled for the compensation. And who can cause the loss? It can be promisor himself or any third party. So what if it is an act of God? Generally, it is not enforceable. But recently, when case law, what is that? Gajanan Moreshwar versus Moreshwar Madanna. In this case, they have taken the help of English law and they have said even act of God will also be covered. When you are writing an exam, write it in this way only. Generally, not possible. However, in this case, this is what has been the judgment. Hello? Okay. Life insurance is a valid indemnity contract. No. Life insurance, no, because you can never make good a life, loss of life. Okay. Now, people, right of indemnity holder when sued. Remember section 125. Lot of times I have asked this. Whenever you did not directly settle the money, I filed a case on the indemnifier, on the insurance company, what and all money they will have to pay me. First of all the damages which we agree. Court tells you pay 1 lakh, you have to pay 1 lakh. Second one, I came to court, I need to pay legal fees, lawyer fees, I can recover that from you. Third one, all sums which may be paid under the terms of compromise of suit. That means what? Imagine the accident charges were some 3 lakh rupees. But we went and agreed with third party, Macha 3 lakhs and all I cannot pay. Can you please reduce the compensation to 1 lakh? So we compromised the suit. We did not go to court. So settlement amount, the indemnifier will have to pay. That is a compromise of suit. Need not be arbitrary. I'm not arbitration. It can be even mutual settlement. I need not even have to go to court. Mutually, if we agree, that also can be the liability of the indemnifier. Yes, sir. Okay. Next one, sir. Contract of guarantee. In contract of guarantee, how many parties are there? There's always 3 parties. The person creditor, he is giving money to the principal debtor, and there is a third party. If he doesn't pay, someone is saying, I will pay. Hello? Correct? Okay. There are 3 contracts in the guarantee contract. One is called as principal contract between the creditor and the debtor. There is secondary contract between creditor and surety. If he doesn't pay, I will pay. Third one is there is an implied contract between surety and the principal debtor saying if I pay, I have a right to recover. And that is only called as subrogation. Very good. Understood? Hello? Yes? Okay. Now, sir, people, whenever the principal debtor does not repay the loan on maturity date, the creditor has to first file a case on whom? Principal debtor, and then on? No, he can directly file a case on surety. You would have seen this in the rights of the third party. You need not proceed against the principal debtor. I have a right to directly file the case on surety. Essential features, principal debtor consideration, okay, existence of a liability, no misrepresentation, concealment, okay. Types of guarantee, there are 2 types of guarantee. One is called as specific guarantee, next one is called as continuing guarantee. Can I revoke it? Both can be revoked provided they have not yet occurred. If the liability has already done, you cannot revoke the guarantee. Same thing in the case of continuing guarantee also. Future transactions can be revoked. Past transaction cannot be revoked. Remember, they have asked questions. Yes. Now you guys only will know which topic is important, which is not important. That's why writing tests, solving questions, again revision is required. You will know which topic to focus more. Are you getting the point? That's why I tell you to read and see more and more and more questions. You do not need anyone to come and tell you this topic is important. Now read letter by letter for that topic. Yes or no? Yeah. Okay, distinction between contract of indemnity and guarantee. What is the difference between indemnity and guarantee? In indemnity, how many parties are there? Here, how many contracts are there? Here, and what else is the difference? Definition, okay, and here there is subrogation now. Surety can recover money from debtor again. Here can I recover? Insurance company, I'll pay now, I'll later recover it from you. Is it possible? That is not possible. Agreed? Yes, sir. So these are some differences, remember. Okay, nature and extent of surety's liability. Surety's liability is always coextensive. If principal has to pay principal plus interest, my liability is also principal plus interest. If his liability has reduced, my liability will also reduce. Next one, liability of surety is of secondary in nature. That means if principal debtor does not pay is when my liability will start. For that 1 year I am not liable. For that 2 years I am not liable. After that I am liable. His liability arises immediately. So I will directly go on you. Fourth one, where a debtor cannot be held liable on account of any defect in the document, even the surety also ceases. Unenforceable contract we saw. The creditor has a right to sue the surety directly without first proceeding against the principal debtor. Here they will ask a question. Remember and go. Important. Liability of two persons primary liable not affected by arrangement between them that one shall be surety on other's default. What is this, people? Let us imagine A and B together have borrowed money from C. Hello? A and B together have borrowed money from C. Now, in between A and B, they have said, Macha, I'm signing it as a joint promisor, but I'm actually signing it to you as a surety. That means what? Together, let us take 2 lakh. In the same document, let us sign it as joint promisor. But in between us, there is a condition. You take entire 2 lakh. Only if you are not able to pay, only then I am liable. So in between us, there is a contract. First you are liable, then I will be liable. Now people on the date of maturity, they did not pay. They did not pay. Now C can file a case first on whom? A or B? A na B na? I can file a case on A or B. In between us, what have we agreed? First liability will be whose? A. If he doesn't pay, who will be pay? So, what is the thing? See, liability of two persons primarily liable, not affected by arrangement between them, that one shall be surety on other's default. So, technically what happened? B did not tell this. If he doesn't pay, I will pay. That and all was not communicated. In between you guys, you have agreed. Whatever you agree in between you, surety will not be liable for that. If you have agreed it with me, then yes, I will not directly file a case on you. I may file a case on you. But if you guys have personally agreed something, that will not bind on me. C can file a case on A directly or B directly. Whatever your private agreements are, it will not bind C. That is what is this rule. Understood? So whatever you guys privately agree, the creditor will not be bound by that agreement, is what is this rule. Understood? Hello? Okay. Discharge of surety. When will surety get discharged? Revocation, conduct of the creditor, or invalidation of the contract. That is only. In revocation, you will see on continuing guarantee, I can give notice. Whatever is the past, I cannot revoke. Future transactions, I can revoke. Past transactions, can I revoke? Revocation on surety is death. Possible, Possible. Past cannot be revoked. Future can be revoked. Past, you will be liable up to the extent of the properties inherited. If that is also not there, then it's a loss, that's all. Then people, by novation, meaning entering into a new contract. By conduct of the creditor, that means what? You are varying the terms of the agreement without telling to the creditor, then variation is discharge. By release or discharge of principal debtor, if I am releasing the principal debtor, surety is also automatically discharged. Discharge of surety when creditor compounds with or gives time or agrees not to sue principal debtor. If at all he is compromising with the principal debtor, that means what? You have to pay 5 lakh, no, you pay me 3 lakh. I will collect from surety rest of the 5 lakh or rest of the 3 lakh. If you enter into any compromise, I give you more time. For all of that people, creditor will also be discharged. Okay, next one. Promise to give time. Discharge of surety by creditor's act or omission impairing surety's eventual remedy. What was that? Creditor took some collateral, gold, and the creditor lost it. The surety is also discharged of that amount. Whatever is the gold, I could have taken it in the future. You lost it. My liability is also reduced by that amount. Next one is by the invalidation of the contract of guarantee. When will the invalidation happen? Whenever misrepresentation or concealment of a fact. Next one is rights of a surety. Against principal debtor. If I have paid any money on behalf of you, I have a right to recover it. This is only called as right of subrogation. Right against a creditor. What are the rights against a creditor I have?
Security received.
Right against a creditor. I have a right against your security received. Right to share set off and
Share reduction.
you have a right to share reduction. One is people, if creditor has taken any gold security, my liability, I also have a right on that security. Second one, people, if the debtor has paid 2 installments, you cannot again collect that money from me. That is only set off. Third one, people, right to share reduction. Imagine if principal debtor became insolvent, you filed a case on him, you recovered 2 of his bikes, you recovered some money. My liability also reduces by that money. That is the meaning of right to share reduction. The last one is right against co-sureties. Co-sureties, people, what will be my liability? How much? As much as possible, the liability will be equal. What is this case? A borrowed 6 lakh rupees from B. The co-sureties are C, D and E. Generally, if nothing is written, all of them are equally liable. 2 lakh, 2 lakh, 2 lakh. Sir, what if the proportions are different? 3, 2, 1.
No.
You always share it equally, as much as possible.
And then remain share according to their extent.
So, for example, if I have failed to repay 4 lakh, 2 lakh I have repaid, 4 lakh I didn't pay. How will I share? First to share it equally, 1, 1, 1. Now, how much more is required?
Only one.
So that do it 50, 50. Understood? This is important. Remember and go. Clear? All of you? Co-sureties done. That is your indemnity and guarantee. Next one is not break, huh? Okay. You want, huh?
Yes.
Huh?
Full complete and
Actually, if possible, we'll do it out. Huh?
Yes, sir.
On the stretch. We can start with new song. Huh? Bebo. Okay. Okay, new chapter. Okay, probably in maximum another 20 minutes we'll finish it off. We'll take 30 minutes break at once. You can go and come. Yes, huh? Yes. Concentrate. Sir, will this be available on YouTube? You want it on YouTube, huh? Okay, we'll put it. Unit 8, people, bailment and pledge. Hey, bailment. Okay, bailment. Important things will taka do it off. Essential elements of a contract of bailment. What are the essential elements? Bailment, people, first thing, it has to be a express or implied. Okay, it has to be movable goods. It cannot be immovable goods. Second thing, there should always be delivery of possession. Custody is not considered as what, people? Bailment. Because in custody there is no control. In possession there is some degree of control. And bailment can be of 2 types. One is called as gratuitous. Next one is non-gratuitous. Gratuitous means, people, there is no consideration. Best example, you giving your bike to your friend. Non-gratuitous is there is consideration. Give and take is always there. You giving your bike for service. And once the purpose is done, you have to get back your product. Only then you call it as bailment. Okay. Next one, sir. Return of goods. Okay, on the bailor. Okay, duties of a bailor. It seems. What are the duties of a bailor? Bailor's duty is to disclose fault in the goods bailed. Agreed? Now, people, there are 2 types of bailment. Gratuitous. Should I disclose every fault? I will disclose only the faults which is known to me. Unknown to me, I am not liable. In the case of gratuitous, free bailment. Non-gratuitous, whether you know it or not, any loss suffered, you are liable. Okay, done. Next one, duty to pay necessary expenses. When is this, people? Duty to pay necessary expenses. What is that? Extraordinary expenses. Now, I have taken a Zoom car on rent. While coming back, there is a repair. Why should I take repair? Fuel, I am liable. Any other extraordinary expenses, I am not liable. So, it is a duty to pay those expenses by the Zoom cars. Duty to indemnify the bailee for premature termination. When will this come into picture? Whenever it is a gratuitous bailment, I have given bailment for free. I can terminate it. I can take it back whenever I want, provided if he has suffered any loss. I gave my bike for my friend for using it for 1 month. He serviced the bike by spending 1,500, and I'm taking back the bike after 10 days only. It is my duty to pay that 1,500 to my friend. Sir, what if it is a non-gratuitous bailment? Can I terminate it? On a normal day, no. But you can terminate it only when you make an inconsistent use with the goods. That means, I'm telling you, you have to use a Zoom car only within the city, but you take the car from one place to another place. Inconsistent use with the terms. Then I can terminate the contract.
Terms and conditions.
Terms and conditions. Yes. Bailor's responsibility to bailee. What is that? First one. Indemnify any loss. If at all any loss, people, I need to pay for it. I told you, I do not have the title. You suffer some loss. I have to pay for it. Next one, it is a duty of the bailor to receive back the goods. People, within time or the purpose. Remember, this is your duty, also his duty. Within time, you should also take it. Within time, he should also give it. If you do not take and he suffers a loss, also you are liable. If he does not give within time and anything happens, also you are liable. Umbrella case. Yes. Okay, next one, duties of a bailee. Take reasonable care of the goods, of course. Not to make inconsistent use of the goods. Correct? If I have given it to you for that purpose, you should use it only for that purpose. Not to mix the goods with your own. What if I mixed basmati and normal rice? Separable. Cost of separation is on you. If non-separable, you have to pay the entire cost. Return the goods once the purpose is served. Yes. Return an accretion, cow and calf. Not to set up adverse title, taking it from you and I am going and pledging it somewhere. My neighbor gave me gold to keep it safe. I went and kept it in Muthoot Finance. Can I do it? No. Rights of a bailor. Right to terminate, we already seen. Premature termination, we already seen. Right to file a suit against wrongdoer. If at all any accident happens, I can file a case or bailee can file a case. Right to sue the bailee. When? Right to claim compensation. Right to claim compensation for unauthorized mixing of goods. Basmati rice is mixed. Right to claim damages for unauthorized use of the goods. Right to demand back the goods. Right to any accretion. Benefits, I can take it back. Rights of a bailee. Right to deliver the goods to any of the joint bailors. Two people came and gave me the bike, I can give it back to anyone. Right to indemnity. If I have suffered any loss, I have a right to take the money from you. Right to claim compensation in case of faulty goods. We have already seen. If at all there was any, whether you say it or not, if there is any damages in that particular thing, any defects, it is your duty to tell. Right to claim necessary expenses. We already saw extraordinary expenses. Right to apply to the court to decide the title of the goods. Sir, in a bailee is not sure whether to give the goods to A or B. What to do? You can ask the court, sir, we are not able to know who the owner is. Please tell me who the owner is. I'll give back the goods to them only. You can apply to the court. Next one is right of particular lien. What is particular lien? What is general lien? If I can only hold that product for that payment, that is called particular lien. If I can hold that product for any payment, it is called as general lien. General lien is generally with 5 people. One is banker, factor, warfinger, attorney of a high court, policy broker. Yes? Okay. Termination of bailment after the period, after the purpose, by notice. Correct? By notice only gratuitous. Non-gratuitous cannot be done. By death and by destruction of subject matter. By void contract. Rights of bail and bailee against any wrongdoer. Both of us can file a case. Yes or no? Finder of lost goods. What is finder of lost goods? Until the money is paid. I'm just telling you in the crux. Section 71, generally we saw there also. What did they say? Whenever I find lost goods, I have certain rights. What is that? One, I have to keep the goods with me. My responsibility will be as a bailee. Until the owner is found, I will only keep it. Now, if I have spent any money, I can recover it from the owner. What if the owner does not repay the money to me? I have a right to withhold the goods with me until the money is paid. Can I file a case on it for recovery of the money? Answer is no. I cannot file a case. However, if compensation is promised, I have a right to file a case and get back the compensation.
Our owner has specified a specific reward, then we can get the...
Correct. That I can file a case and I can get that money. Next one is, if at all it's a perishable goods, I have a right to sell it. And if at all the cost involved in finding the owner is 2/3 of the value of the product, and he is not denying, he is not agreeing to pay the money also. In such case, I can sell it and I can recover my money. Finder of lost goods, remember. The last one is people, pledger. Pledger duties and all will be the same, but only thing you need to remember is in pledger, there are 2 parties, pledger, pledgee. Pledge is always a bailment for security, that's the definition. it's a bailment for security. Yes, Sam. Extraordinary expenses, right to payment will make a default. Okay, duties pledged by non-owners. Non-owners, we said we will do it in later point of time, you know.
Sale of goods, sir.
Okay. I think this is manageable. The duties and rights will be similar to whatever we saw in bailer and bailee only. That one thing you see.
The pledge of a movable good. So movable good bailment is pledge.
It's always bailment is always movable goods. Whether pledge or bailment, it's always movable goods. It can never be movable.
Property, it cannot be property.
Okay. The last unit, unit 9, sir, agency. So people in agency, there is always three parties. One is principal, agent, and third party. Now, sir, principal and agent, who can be incompetent people?
The agent.
Agent can be an incompetent party. So he can be an unsound mind person or even a minor. But remember, if principal has given any scope, if agent has acted beyond the scope, if it is a normal agent, meaning who is a major, in such case that major will be liable. But if at all you have appointed someone who is unsound mind or a minor, in such case if they act beyond their scope, it will be always the responsibility of the principal. Okay. Creation of agency, it can be created express or implied. Implied includes two types. How is express is power of attorney by words or written. You are clearly telling that you need to create an agency. Implied means people based upon necessity, circumstance. Necessity and estoppel was the example. What is the agency by estoppel? When the agreement was done, that is an estoppel, you are creating, the principal is creating a circumstance that the invalid acts of the agent are valid. I am inducing a belief that whatever he did without power, he has power. I'm inducing the belief. In such case, people they are telling that there is an agency created. Agency by estoppel. Next one is called people necessity. What is necessity? Emergency. In emergency, there were certain rules you need to satisfy. What is that? Agent should not be in a position to communicate to the principal. Agent should have acted like an ordinary man. How he would have treated his goods at that point of time. He should have treated it that way. And third one, it should be commercially required, whatever decision he has done. Fourth one, he has always chosen the best alternative available. If all these things are satisfied, agency by necessity will come and I should be in possession of the principal goods. And whatever I do, the principal will be liable for that. Agreed? Okay. Next one is people, agency by operation of law. Operation of law is nothing but people. So it is by law. Example I can give you is liquidator, partnership, which is not by us. Law says you guys are principal and agent relationship. Okay, next one is ratification. What is ratification, people? When the agent did something, he did not have the authority. He did it off. Principal later makes the agent's act valid. When you did it, all those things were invalid, but I later on made it valid. Such type of things are called as what, people? Ratification. Okay. So for ratification, certain things are to be satisfied. What is that? It must be express or implied. Full disclosure required for ratification. And it has to be a whole ratification. You can never do a ratification in part. And you can never ratify an illegal act. Third floor, terrace, weed. That you cannot do it. And remember, whatever is a thing that causes injury to a third person, that cannot be ratified. You have to do it within reasonable time. Remember, ratification is important. They can ask you the rules of valid ratification. Yes? Okay. Next one, sir. Extent of agent's authority. Agent's authority in normal circumstances, agent's authority in emergency. He can do only within the scope. In emergency, he can go beyond the scope as well. Subagent valid. Subagent is generally not valid. Section 190. But in 3 cases, it is valid. When the contract provides, second one, when the custom of the trade, third one, emergency. So one is contract only provides for appointment of sub-agent, allowed. Second one is custom. We saw it in the case of event management or constructions. It is a custom. I will appoint someone else. Third one is necessity, emergency, unforeseen scenarios. Now, we saw it. Sub-agent is nothing but there is a maxim called as delegatus non-potest delegator. That means a delegatee cannot further delegate. So in general, a sub-agent is not valid, but exceptions are there. If it is not properly appointed, principal is not bound with whatever a sub-agent does. Then whose responsibility it will be? It will be agent's responsibility. One more thing, there is never a privity of contract between principal and a sub-agent. So sub-agent can never file a case on principal for remuneration or any such things. So the next concept is substituted agent. What is substituted agent? An agent appointed upon a reference given by a other agent. Now in that case, what is happening? If an agent has acted like an ordinary man, if you have taken sufficient care in referring a person, your liability comes to an end. However, if you do not take proper care, now your liability will be there if at all principal suffers any loss. Remember, in substituted agent, there is privity of contract between substituted agent and principal. Whatever the substituted agent does, principal will be liable. Principal is liable to compensate the substituted agent for remuneration. Hello? Done. Okay, next one, sir. Okay, duties and obligation of an agent. Duty to execute mandate. Principal clearly told, my goods are there, take insurance on it. It is a duty to take insurance on it. Duty to follow instructions or customs, meaning if I tell you to follow some instructions, follow that. Can I give some goods on credit to someone? Can I give it? Follow instruction. If I told you to give, give. If not, don't give. Sir, what if you have not said anything? Then follow customs. In your trade, is it regular to give some goods on credit? Then give. Okay. Next one is duty take reasonable care. I will give it on credit, provided you use your brain little. Is that person worthy to get the goods on credit? Use your brain. Next one, agent duty to communicate with the principal. Whenever if you are not able to make decisions, it is a duty to communicate with the principal. Duty to avoid conflict of interest. One more point for this is you cannot make secret profits. So you cannot deal in your own account. Hello? Next one. What is that? Duty not to make secret profits. Duty to render proper accounts. You have to give proper accounts. Duty not to delegate. Agent's duty to pay some receipt for principal. Whatever I have received for you, I have to give it to you. Duty not to use any confidential information against you. Right of an agent. Right to retain out of the sums received on principal account. So I have a right. If you do not pay me for these things, whatever is the money I have collected on your behalf, I can keep it with me only for these things. If I have paid, what and all? Remunerations, advances, any expenses paid for the business. Next one, I have a right to remuneration, of course. Agent's lien on property. Agent has a particular lien. If your property is with me, I can keep it with me until I recover all the money that you have to pay to me. Okay. Right to indemnity. Because of you, if I suffer any loss, it is your duty to give it to me. Principal said, get a business. I got a business, but you failed to supply the material. He will file a case on me. You are liable to repay the money for it. Non-liability of employer of agent to do a criminal act. A tells B to kill C. If B kills C, A is not liable under Indian Contract Act. In a BNS, you are liable. Right to compensation for injury caused by principal's neglect. So if I tell you to do something and if you do not do it, I am liable. And one more thing, what is that I told you? Principal's neglect. I tell you to carry 100 kgs of iron rods in a truck, in an auto. If you carry, even after knowing I told you to carry, anything happens, I am liable. That is what I am telling you. Hello? Principal or agent's liability to third parties. Principal liability for the acts of the agent within the scope. Agent does anything within the scope, people. For that, principal only is liable. What if the agent exceeds the authority? Agent is liable. Yes. What if the agent exceeds the authority? If the contract is separable, then I am liable to the extent I have given you the power. Beyond that, agent is liable. the contract cannot be divided at all, then for the whole contract, agent is liable. Principal not bound when agent exceeds the authority. We saw this. Principal not bound when excess of agent is not separable. We saw this. Consequence of notice given to agent. Anything intimated to agent is equal to intimating it to principal. Agent cannot personally enforce nor be bound by contracts on behalf of principal. What do you mean by that? Agent is not bound by any contracts entered on behalf of principal. It is always principal's liability. However, there are exceptions, no? Effect on agreement of misrepresentation or fraud by agent. If an agent does any fraud, in the scope of business, principal is liable. Beyond the scope of business, agent only is liable. Right of third parties. The right of parties to contract made by undisclosed agent. What can I do? Undisclosed agent. Shah Rukh Khan case. I did not tell the name of the principal. If third party, before the completion of the contract, if third party wants, Wankhede Stadium can still cancel the contract. Next one is performance contract with agent supposed to be the principal. Whatever the agent has agreed, principal has to perform it. He cannot stop it because the third party has assumed agent itself as principal. So whatever promises the agent has made, the principal has to fulfill it. The option of third party to sue the agent or principal. So the third party has an option, it seems. In these cases, if you want, you can file a case on agent, or if you want, you can file a case on principal. When right of person dealing with agent, personally liable. Meaning agent, agent has clearly told, sir, if anything happens, you come to me. I will come to you only because you have clearly said I will be personally liable. Consequence of inducing agent or principal to act on belief that principal or agent will be held exclusively liable. So again similar scenario where if principal has said I will be exclusively liable, principal will be exclusively liable. Agent will be exclusively liable. Agent will be exclusively liable. Next one is liability of principal inducing belief that agent's unauthorized acts were authorized. Estoppel. So if I have said whatever agent is doing, for that I will be liable. If I have said that, I will be liable. That is what we saw agency by estoppel. So termination of agency. How and all agency will get revocation? Possible? Revocation, renunciation. We have seen something. If at all you are entering into a contract saying that I have appointed an agent for 1 year. Now can I revoke it in third month? Yes, provided I have to pay compensation. Can he resign it in third month? Yes, it's called renunciation, provided he has to pay compensation. But certain contract cannot be revoked. Which one? Where agent is, he is interested in the subject matter. I told you to sell that land and recover the loan that I need to pay to you. Such agreements cannot be revoked. And when is revocation effective? When the principal wants to revoke. From the day the agent is aware of it, when he reads the letter, the revocation is effective. When is a third party agency coming to an end? Whenever the third party gets to know about it, that is when the agency comes to an end. Okay. Next one, renunciation by agent. We saw completion of business on expiry of time, death, insolvency. In all these cases, it comes to an end. When the agency is irrevocable, when it is, agent is interested in the subject matter, whatever we saw. In that, agency is irrevocable. Clear? That is what we saw now, effect of termination. When does it come to an end? When agent gets to know, when third party gets to know. So, okay. That's it. Go for a break and come. So, within 2 hours, we revise unit 9 units. Go for a break and come.